So a common question I get asked is, well, how do I get sole custody? Or a client will come into my office and tell me that he or she wants sole custody of the children. And I always counter that by asking the client, well, what does sole custody mean to you? Because in the Texas Family Code, we don't use the word custody. I mean, not to say that it doesn't appear in the Family Code, but what is popularly perceived or the popular definition of custody is different than what's in the Family Code. So if you ask most people on the street, or if I ask my clients what sole custody means to them, they assume that it factors in what the visitation schedule is going to be or how much access the other parent is going to have to the child. But in Texas, we use the word conservatorship. And conservatorship means rights and duties. It has nothing to do with what the visitation schedule is going to be. So you can be appointed what's called sole managing conservator, which means you will have the exclusive right to make certain important decisions on behalf of your child, like, for example, educational decisions, the exclusive right to designate the child's primary residence. What geographic area are you going to be able to designate the child's residence within? Who's going to have the right to make or consent to invasive medical procedures? Who's going to have the right to consent to psychological or psychiatric treatment for the children? Those are the four main rights that parents generally fight about, that they care about the most. There's lesser rights in the Family Code, like consenting to marriage or consenting to enlistment in the armed forces, or managing the estate of the child. If, for example, your child became a child actor, and who's going to have the power to manage the child's earnings? Obviously, those are things that rarely come into play. But when you ask or you think about sole managing conservator, if you are appointed sole managing conservator, you have the exclusive right to make educational decisions, to consent to invasive medical procedures, to consent to psychological or psychiatric treatment. But it's rarely awarded in Texas. Generally, a court will appoint one parent sole managing conservator in two circumstances. One, if there's a history of family violence, if one parent has been victimized and abused by the other parent, then the court does not expect that parent to have to confer and seek agreement from the abuser. And that's why the parent who's been the victim is going to be appointed sole managing conservator in a situation involving family violence. Another scenario where a court may appoint one parent to be sole managing conservator is if it's a high conflict co-parenting dynamic. If there's a history of the parents not being able to agree on issues on behalf of the children, if the communication between the parties is extreme and negative and nasty, then the court may appoint one parent sole managing conservator. But these are rare circumstances. In over 90% of cases, parents are appointed what are called joint managing conservators, which means they have to make these decisions like educational decisions or consenting to invasive medical procedures or consenting to psychological, psychiatric treatment. They have to make those decisions by agreement. And if down the road they can't agree on some important decision, then they may have to go back to court and a judge is going to decide what's in the child's best interest. But again, I want to underscore this issue about conservatorship, that is separate from the possession schedule. So parents may be appointed joint managing conservators, but that doesn't mean that they have equal visitation. One parent may still have a majority of the possession time, even in a joint managing conservator scenario. Same thing with sole managing conservatorship. If you're the sole managing conservator, that doesn't mean that the other parent doesn't get any possession or access to the child. In fact, what we call the possessory conservator, the other parent, will still have a standard possession schedule even in a sole managing conservator situation. So it's important to recognize that there's a distinction between those two concepts. There's rights and duties on the one hand, and there's the visitation schedule on the other.